Hey everybody, how's it going? And welcome back to Copper Jacket TV. So I got some breaking news today. Just finished watching oral arguments at the Ninth Circuit Court of Appeals in Duncan v. Bonta, which is the case that challenges California's ban on magazines that can hold more than 10 rounds. We have been waiting for these oral arguments for a long time. I think it was just a little bit over 5 months now. But we finally had the oral arguments, and you guys are definitely going to want to hear what happened and what I think the outcome is going to be. And I've got some clips for you as well. So let's get to it. Hey, real quick, thank you all very much for watching. I really do appreciate it. If you wouldn't mind, hit that subscribe button and that little bell notification. It's free. It only takes a second, but it really does help us spread our message. So with that being said, let's get to it. Okay, so let's go and talk about what's going on here. So Duncan v. Bonta is a case that has been going on for what feels like forever now. This is a case that started pre-Bruin. We had a decision by Judge Benitez who said that the magazine ban was unconstitutional. That led to the first Freedom Week. Then it goes up to a 3-judge panel of the Ninth Circuit who agrees with Benitez, and then it goes up to the full panel of the Ninth Circuit who disagree. Either way, it's gone back and forth, and we went back down to Benitez and then back up to the Ninth Circuit. Now, when it went back up to the Ninth Circuit, instead of going to a 3-judge panel where I believe that it should have gone back to, they decided to take it en banc and skip the 3-judge panel altogether. And that's kind of where we're at today. The en banc panel, 11 judges in the Ninth Circuit Court of Appeals, heard arguments from both the plaintiffs and the defendants in this case being the state of California. Now, there was one theme that pretty much stayed true throughout all of these oral arguments, and that was the common use test. The common use test was pretty much brought up throughout the entire thing, and whether or not in common use for lawful purposes or in common use for self-defense was an issue. Another issue that was brought up pretty consistently was whether or not the Second Amendment text is even implicated, which is kind of where the defendants or the attorney for the defendants seem to be going with his case, stating that these are not considered arms, they're considered accessories, and that was actually parroted by one of the judges on the panel as well, so we can kind of figure where that judge stands on this. The judge says, well, they're really more accessories than arms, aren't they?
I'm still not sure you've answered Judge Gruber's question. At least you have. I'm still confused. Second Amendment does not protect non-arms, does it?
Well, I think it does not protect non-arms unless
Well, does it protect this?
I think what this circuit has said in Teixeira and other cases is it protects arms and it protects certain other things if they are necessary to the realization of the core right to self-defense.
Fair enough. So I guess I'm stuck on what Judge Graber was asking you. If we were to determine that a large caliber magazine by itself is not an arm, it's not used to attack anybody else, and it's not necessary for the operation of a semi-automatic weapon, do we have to go further than that?
Your Honor, I don't think you do have to go further than that. That is our argument.
Now, thankfully, the attorney for the plaintiffs came right back at that argument when she had her time to speak and said this.
The state's efforts to resist that conclusion are fundamentally incompatible with what Heller instructs and Bruin instructs are the definition of the term arms and the historical tradition about what kinds of arms the state may ban consistent with the Second Amendment.
Now, the court was clearly split on whether or not they considered them to be protected by the Constitution, but there was even a time where a judge said that the ban didn't really ban the use of something because while, yes, the ban on anything over 10 rounds exists, you could still use something that had less than 10 rounds and sort of implied that because you could still use something that was less than 10 rounds, that you should be able to ban anything that is over that limit.
You understand my question? In other words, merely carrying the weapon with a magazine in it, ready to fire, is the deterrent. I don't think the intruder is looking at the number and counting them out. So why isn't it equally usable for self-defense with a 10-round magazine?
One of the other themes that was brought up quite a bit was the dangerous and unusual test. I couldn't believe my ears. I honestly could not believe this. But it seemed like several of the judges up there were questioning whether or not it is the test is dangerous and unusual. Several of the judges seemed to imply that really what they meant to say at the Supreme Court was both dangerous or unusual, and that we have to look at the context of things when we take a look at the actual text of the Supreme Court's decisions and opinions, instead of just looking at the words. When the words say dangerous and, right, which would mean that it has to be both dangerous and unusual, they suggested that it's or. It's not and, it's or, and it's just how you look at it.
I want to make sure I understand. Are you saying dangerous and unusual together, or dangerous and or unusual?
So I think Justice Alito is right that it's a conjunctive test, dangerous and unusual. It has to be both of those things.
And do you have any other?
That's not, as I said before, where this language generated from. The language generated as a adjective for weapon, and it essentially meant, or could easily have meant, dangerous weapons and unusual weapons.
Sure, but I do think we have to take what the Supreme Court has said about it. And
That's
the
what
Supreme
it said.
Court,
Yeah.
the Supreme Court has articulated, when the Supreme Court talks about the dangerous and unusual test, it contrasts the concept of in common use today with highly unusual in society at large.
That's the unusual part, but it doesn't mean it has to be dangerous, both dangerous and unusual.
I don't
Now,
see.
is there anything in the Supreme Court opinions that says that?
Well, what the Supreme Court said, I mean, it was critical to the holding of Heller that the court said that the state cannot ban arms that are in common use today. That had to be resolved because there was a debate in the
You're
case.
not standing on the notion that it has to be both dangerous and unusual.
Yes, in order to be banned, it has to be dangerous and unusual. I mean, that's what unusual means, not in common use. The court specifically contrasts the language when talking about dangerous and unusual of in common use as opposed to highly unusual in society at large.
So clearly there were some judges on that panel that are just not going to have their minds changed. It's all about an agenda. It's all about siding with the state, which is what they did with the last time. They're more interested in just going through the steps and getting to a conclusion rather than actually hearing things out. As a matter of fact, it felt like they were significantly more combative with the plaintiff's attorney than they were with the attorney from the state of California. That being said, the attorney from the plaintiff's attorney in this case, so Virginia Duncan's attorney in this case, handled herself perfectly. I mean, she did a great job. She had a rebuttal for every argument. She knew her facts and she knew her statistics. She had a couple little stumbles along the way, especially when talking about full auto stuff. But for the most part, she did a great job and held up to a lot of the questioning that I would say would be like negative questioning from the court. Now, you guys probably don't remember this. I don't even know why I'm asking. The video that I did 5 months ago, I mentioned that one of the questions that was presented, or one of the questions that the Ninth Circuit wanted the attorneys from both the plaintiffs and the defendants to answer when the oral arguments happened, was whether or not the Ninth Circuit even had jurisdiction to rehear this. Now, remember, I said that they skipped the 3-judge panel and went to the full 11-judge en banc panel on this one. And so that question was presented to the defendants and also presented to the plaintiff's attorneys on this. And that was a lot of overtime. So remember I told you it went a little bit over an hour? There was a lot of discussion on whether or not they even had jurisdiction. And what surprised me is that it seemed like at least maybe a majority of the court, or close to a majority of the court, didn't know whether or not they were actually legally able to do what they were supposed to do. There were some judges that had pretty strong opinions on the matter and felt like they had jurisdiction, but there were some judges that were really questioning whether or not they should even be hearing this. Okay, so with that being said, let's talk about what I think is going to happen here. Now, I don't have a crystal ball. I can't see into the future, but just based off of the judges' reactions and the questions that they asked and what they did afterwards, you can kind of get a feeling for how the court feels. And there's several judges on that 11-judge panel that seemed like they were immovable stones. Okay, they didn't care what the argument was from the plaintiffs. They seemed to side with the defendants, with the state of California. All of their line of questioning led to either it came from ignorance or it just was looking for ignorance, whatever it was. They just didn't seem to care. And I don't think those judges are going to be movable at all. I think they already made their decision well before this ever got there. And that was just the end of it. However, I did see some judges that seemed to kind of maybe change their line of questioning or their thought process when the plaintiff's attorney got up there. And it was interesting to see that happen. So it seemed like they cited for California, but then after the questioning with the plaintiff's attorney, it kind of felt like their questioning actually became a little bit more favorable towards the plaintiffs in this case, and maybe towards some Supreme Court precedent in Bruin and, you know, some of the analytical things that were brought up. And so right now, I'm 50-50, which is really hard to say when it comes to the Ninth Circuit. I feel like the Ninth Circuit is going to side in the favor of the state of California, but in my mind, right? So that's what my heart says. But in my mind, I feel like from what I watched, it could honestly swing any way. And I find that very interesting. If it does, it'll be by a very, very small margin, I'm sure. But still, we have an odd number of judges, so we could be looking at, a 6-5. Either way, we just need that slight majority. We don't need the whole court to see things our way. We just need at least 6 judges to take a look at this and give us that majority. And so there is a chance here that we could see the Second Amendment hold up in favor of the plaintiffs. Now, if that happens, I don't think that the state of California would actually appeal this up to the Supreme Court, because I think they know where the Supreme Court sits on things like this. I mean, the Supreme Court's pretty much already ruled on this. When they ruled in Heller, when they ruled in Bruin, when they ruled there, they basically already ruled in this case. We're just kind of rehashing it up because the state of California obviously decided to ignore it. But this is a topic that's already been determined by the Supreme Court. If California wants to bring it up there, go ahead. But if the Supreme Court decides to take it up, you could be looking at having all bans across the country completely wiped out if you do that. So you run that risk if you bring it up there. So a favorable ruling from the Ninth Circuit here might just be allowed to stand. So again, I'm trying to be optimistic. I'm trying to be hopeful. The attorney, again, for the plaintiffs did a fantastic job arguing her points and making a case that these are arms protected by the Constitution, that the Supreme Court has already ruled on this. And so there's not really anything else to talk about. We don't even need to go into historical precedent because the Supreme Court has already given their decision on cases like this. Anyway, it was something very interesting to watch. And if you want to, I'll put a link down to oral arguments down below. You guys can watch that later on if you get bored or, you're just a nerd for this stuff like I am. So I wanted to share that with you. We'll see what happens, but now we're in that waiting phase. Oral arguments are over in this case, and now we just see what the Ninth Circuit decides to do with it. Anyway, I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.